Hello, and welcome to Williams Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'll be joined by Zan Gormley, an attorney in our Litigation and Labor, Employment, and Immigration section, to discuss best practices for avoiding or being prepared for ERISA litigation. How are you doing today, Zan?
I'm doing well, Brydon. Thanks so much for having me on the podcast.
Yeah, welcome to Williams Mullen, and thank you for joining us on the Benefits Companion.
Very glad to be here.
You and I really kind of occupy two sides of the same coin. As an ERISA attorney, I'm kind of like the building inspector that makes sure that the sprinkler system works and the smoke detectors are in place to try to keep the building from catching on fire. But if that happens, you're kind of the fire department that comes in and handles the crisis if an employer ends up in litigation over an ERISA matter. And so I thought it'd be great if you could kind of walk us through some things that you think are the best practices for employers to stay out of trouble. And if they get into trouble, if they have litigation, what are some best practices to help make sure that they're prepared for that eventuality?
Sure. And my wife loves the show Chicago Fire, so I'll have to brag tonight that I'm a hunky fireman because she certainly doesn't think so. Well, I think that's a great lead-in and a great metaphor, Brydon. And today, what I wanted to talk about when presented with this topic was a certain type of ERISA litigation, which I think presents the proper lens to view preparing for and being ready for ERISA litigation. And that is denial of benefits claims under ERISA Section 502, because those are really probably one of the most, if not the most common types of claims that employers and their plans will face. And a lot of the issues that are involved and a lot of the best practices are generally applicable and good things to follow for all other kinds of ERISA litigation. As you know, ERISA Section 502A gives plan participants and their beneficiaries the right to bring lawsuits to obtain benefits under the terms of the plan that they believe have been improperly denied. As we all know, ERISA has very complicated standing provisions, but 502A couldn't be more clear, especially as far as ERISA goes. Right. And it gives these individuals that right. And the federal dockets, the district courts, they are loaded with these types of claims. There's no shortage of case law and jurisprudence on them. And in fact, some of them have even made their way up to the Supreme Court. Not so much with the Supreme Court deciding a question of fact, of course, but getting into issues of the law that should apply when these cases are adjudicated. So it's a very interesting area of law, very common area of law, and one that is not necessarily always developing, but one that is dynamic. And so I think it presents a good angle to view ERISA litigation.
Yeah, I mean, you're right. And a lot of my practice is drafting plan documents, drafting summary plan descriptions, SMMs, participant notices, and I often joke that I'm writing them for the plaintiff's attorney. Because a normal person who's not a benefits geek probably doesn't pour through the summary plan description, but I know that I've got to put language in these documents to help protect my clients against the potential claim. And the type of claim that I'm most concerned about is exactly what you said, is a claim for benefits.
Right. Well, and that's a perfect segue to what I'll call our best practice number one, and that is to make sure plan documents contain the Firestone tire language. What does that mean? From a broad perspective, ERISA denial of benefits claims are based on really just a dispute between the claimant and the plan administrator over the terms of the plan language and whether or not that individual meets the conditions that the plan document sets forth for being entitled to that benefit. The administrator has the job of interpreting the plan and also has the discretion to make the interpretation, because the idea is, look, you're the administrator, it's your plan. You know better than a court how best to administer your plan. However, and this is where we get to the Firestone tire language. The court is only going to apply that level of deference if the plan document expressly gives the administrator that right. It seems a simple thing, but it's not necessarily, and you would be surprised how often plan documents do not contain that language. Mm-hmm. The language is called Firestone tire language among us lawyers and benefits people because it dates back to a 1989 Supreme Court case where the Supreme Court decided district courts reviewing a plan's decision based on their plan documents will be accorded broad deference provided their plan document says that they should be given that deference. Again, seems kind of elementary. Why did it take the Supreme Court to state that? But some of the most hoary principles and laws often are elementary. And so the best practice tip for that is review your plan's documents and make sure it has this language. If it does, then the court is going to have to give you that deference, and it's going to set the plan up to be in a position of strength when these claims are litigated. It's also going to set the plan up to not necessarily have to litigate cases, because if you're an attorney, and like you said, Brian, if you're a plaintiff's attorney evaluating a claim, the first thing you're going to do is look for that language.
Right.
If you look for it and you find it as a plaintiff's attorney, you're not just going to take your ball and go home, but it's going to make you view the case from a different lens and say, wait a minute, we're starting with an uphill battle here. If that language is not in there, the court doesn't have to accord any deference to the plan administrator's interpretation, and it looks at things on what's called a de novo basis. And it basically just means it's looking at it from fresh eyes. The court does what a court typically does at the trial level and gets to evaluate all the evidence in front of it and make its own judgment calls without saying, well, here's what the plan administrator did, and so I really sort of have to just find that reasonable. Instead, it can say, look, here's what I would have done if I was the plan administrator.
Right. The court, without the Firestone language, the court really puts itself in the shoes of the plan administrator and is doing what we would consider the plan administrator's job of interpreting the plan and applying the facts to the terms of the plan. Then when we as employers don't want that, we want to control that, and we want the administrator's decision to stand that abuse of discretion scrutiny, which means even if the court disagrees, may have come to a different conclusion, is as long as the plan administrator didn't abuse its discretion, the court will defer to the decision. And that's really what we are seeking here with the Firestone language.
That's exactly right. And you hit on a great point, which is the abuse of discretion standard is what applies when you've got that language. And people often wonder, what does that mean to abuse discretion? Really, it just means, simply put, was the plan administrator reasonable? Now, reasonable is one of those legal buzzwords that can almost mean anything, but it's a very favorable standard because these claims disputes, as you know, are often very complicated and very contentious. And they're oftentimes close calls. And you don't want to put a court in the position of saying what judges love to do is, here's what I would have done.
Right.
Because that's what judges get paid to do and what they think they're very good at, and often very times are. So putting that in there allows you to, as a lawyer defending the plan's decision, to have a much easier burden. And basically, you don't have to say necessarily what they did was absolutely the best, most correct decision. Without a doubt, there's no other decision that could have been made. It's, Your Honor, based on the evidence presented, this was a patently reasonable decision. And that makes it a lot easier for the court to affirm what the plan has decided.
Yeah. And, I think, Firestone is a case from the 1980s, the late 80s. Probably most plan documents are going to have the Firestone language. They should. And as you said, often, you see that they don't, especially when you get to litigation. But employers may be missing their summary plan description. They may have the language in their plan document, but not in the summary plan description. And there was a case out of the 10th Circuit from last July. So this is a 2020 case out of the 10th Circuit where the plan document had the Firestone language, but the SPD did not. and the court applied the de novo standard because participants were put on notice that the plan administrator had discretion. Now, I personally disagree with that analysis because the plan document is supposed to control participants' rights. And I don't know what the participants would have done differently had they been on notice that the Firestone language was in the SPD. So, but that said, that's how the 10th Circuit ruled. And so I think you're right. Employers should review their plan documents, but they should also be reviewing their summary plan description. And I think if the Firestone language is going to be missing, it's more likely that they may have it in their plan document, but it might not be in their summary plan description.
Right. I think that's a great point. And there's no penalty for being redundant, right?
Right.
You can have it in your plan document. You can have it in your SPD. You can have it in your plan brochures. You can have it on your website. There's no penalty for stating it too many times. But as you pointed out, there could be a penalty for not having it somewhere. So it's always a good idea. And again, you don't have to go overboard, but it's a good idea to periodically review or to maybe do a regular or at least one time audit, if you will, of your plan documents to make sure they're all in there.
Right. So what are some other things that employers should be thinking about when they're thinking about being ready for litigation?
Sure. And this leads to the best practice number 2, which is make sure the administrative record is thorough and complete. What does that mean? Briefly stated, ERISA denial of benefit cases are almost always decided by the court based only on what's called the administrative record. And that's the documents that the plan administrator relied on in making its decision to deny the benefits. So when these cases go to court, it's not like most other litigation where the parties can take discovery to develop and go look for additional evidence or can bring in additional evidence to support their claims or defenses. The court is really strictly looking at what the plan administrator used to decide his decision. Typically, if it's a disability benefits claim, it's going to be the medical reports, the medical records, and the notes of any decisions or any hearings. As we know, sometimes plans can have hearings, and anything else that essentially the administrator relied on when ultimately making its decision. There's a benefit to plans to that concept because it saves plans from the expense of going through discovery, which, as we all know, is often the most expensive and time-consuming part of litigation. But it's not without its traps, because if a plan goes into litigation with a thin record or an underdeveloped decision, it can't then work with its attorney to bring in new evidence that it further supports its decision. So it's always good to be mindful of the fact that both parties are going to be stuck with the record for better or for worse. And the plan wants to be sure to really, just like anything, document its decision. Make sure its decision is well documented and thoroughly explained. Again, it's all a matter of reasonability, so you don't have to go overboard with thousands upon thousands of pages. But look at things through the lens of reasonable. If I was a judge, especially if my plan has the Firestone language, and I'm deciding, was this really a reasonable decision? Are there documents in the record that back it up? Or are we saying things in a kind of a cursory or conclusory manner because it might seem obvious to us as the decider, but might not seem obvious to a court who's taking a fresh look at?
Yeah, and that's something we also, I often tell investment committees for 401k plans that, outside the context of benefit, claims denials, but it's not, you don't violate ERISA if you made a bad investment decision or retained a bad investment option in the plan that, participants may have lost money, but you have an ERISA violation if you didn't do your due diligence, if you didn't, carefully review investment performance and fees. And it's so important to document that process. So again, along with the claims, documenting the claims process, it's also important to document other fiduciary decisions. Basically, any fiduciary decisions, you need to have a record so that you can show the court that you did your due diligence, that you met your fiduciary responsibility, even if the decision maybe turned out in the context of an investment option not to be the right decision. If under the facts that you knew at the time, it was a reasonable decision, that's what you need. You need that administrative record. And so we talk to our investment committee clients all the time that they need to keep accurate records of their process.
You're absolutely right about that. And war stories are from experience. I have been involved with representing plans of their fiduciaries in Department of Labor investigations. And that's the first thing the Department of Labor wants to see is the record that backs up these decisions by the plan, and whether it's to retain a professional or to make a certain investment. And I can tell you from experience, when there is a robust record up front, that makes the tenor and direction of the investigation much more favorable to the plan, because you already have the investigator from EBSA or for DOL who gets a sense of, okay, this is a plan that was doing what it was supposed to do. And all of a sudden it goes from them questioning to them wanting to work with you and figure out and resolve and come to a amicable conclusion or resolution.
So that kind of takes us to the next best practice I think that you're going to discuss. So we need to document our processes. How long do we need to keep records of the claims process?
Absolutely. Well, look, with document retention policies, there's no sort of magical number, right? And every organization is different. Some employers generate massive amounts of data. Really, all employers do now when we're living in the world of metadata. But some employers, if they're in a tech-heavy industry, generate more data and more documents than perhaps an employer in a industrial or more physical world-based. But so there's no real rule of thumb for the amount of time or years, but it's just like anything. It needs to be defensible, and it needs to be tied to your needs and real world practices. So if you're an employer and you say, we shred and get rid of every bit of document and data every 6 months, that's probably not a reasonable policy. But if it's 3 years, maybe it's 7 years, and you have a reason for that, that's more defensible. But I think the bottom line is you need to evaluate the types of employees you have, the type of business you're in crafting that policy. Particularly if you're an employer who's been around for a long time and you might have a retirement plan or a plan that provides for retiree medical benefits, you're not going to want to get rid of documents for individuals who are still employed and are coming into retirement status soon, or for people who are your retirees, because you might be faced with claims from those participants or their beneficiaries. And you don't want to be in the position of saying, we don't have any records and therefore we can't verify your claim. That's going to be viewed as not particularly reasonable, even under the Firestone standard.
Yeah, I mean, clients sometimes ask me, how long do we have to maintain records? And we review document retention policies. And I just don't, I know it's unrealistic, but especially like with a pension plan, I don't want anything to be destroyed. I keep it forever because it'll come up that, we have an employee who worked for us from 1985 to 1996, and they're disputing their benefit calculation now, and we don't have records.
Right. So
to the extent that you can keep them within reason, I err on the side of retaining all the documents that you can.
That's absolutely right. And unless the cost is so prohibitive, which in this era when things can be boiled down to terabytes and little pieces of bits and zeros and ones, and makes it a lot easier to store, I'm with you in that regard.
Yeah. So what are some other best practices?
When there is conflicting evidence in favor of the participant's claim on one hand, against it on the other hand, the plan administrator, just like it has to make sure it's got a robust documentary record, needs to make sure the reasons why it has credited certain evidence over other evidence is clear. Again, even though the plan administrator is given broad deference, especially if that Firestone language is there, that doesn't mean it can just say or decide whatever it wants. And a court's going to say, well, hey, the administrator obviously knows what he's talking about. So let's take an example of this. Let's say you have an individual who's applying for retirement benefits. the benefits are based on how many years he was a supervisor versus not a supervisor. And his employment goes back 30 years. Unfortunately, the records aren't totally complete because understandably this employer has merged over time. The employees' records have been moved around and records get lost. That just happens sometimes, particularly when records date back to the pre-digital era. So you're left with a situation where you have to go back and find people who worked with this individual. Some say, oh yeah, I remember him. He was my supervisor from this date to that date. Other people say, I remember him. No, he was never a supervisor. And okay, you're the employer and you're trying to figure it out. If you decide to side with those people who said he was never a supervisor, it's not enough to just say, we found those individuals' accounts more credible, or we found those individuals to be more reliable. That's a perfectly fine decision, but back up that decision. Explain why. Explain, well, those individuals gave us notarized affidavits. Those individuals gave us specific details that were actually corroborated by other details in his employee file, and explain that. Because when a court's reviewing that decision, it's not going to just say, oh, sure, they found these people more credible and went with that. It's just like anything. The court wants to know that the decision was reasonable and why.
Right. In some courts, even if you have the Firestein language, apply kind of a sliding scale of deference, it's been referred to. So right. if it's a self-insured plan and it's the employer making the decision, then some courts will say, well, yeah, you have deference, but we also know there's a conflict of interest because it's coming out of your pocket. I think more often it's in the case of an insurance company's decision. The insurance company is paying the benefit and they're also denying the benefit. And so some courts apply this sliding scale. So if there is a potential conflict, you really need to be able to be sure that you can support the decision.
No, you're absolutely right. And that actually one of the Supreme Court cases after Firestone, which was Metropolitan Life, MetLife versus Glenn. That goes back to 2008. And the court there decided that when you have a plan administrator who also pays for the benefit, there's an inherent conflict of interest. And therefore, we're going to not say that conflict of interest changes the standard, but it's a factor to be considered when deciding whether the plan abused its discretion and acted reasonably. And if you have a situation in which the plan's decision was cursory and that sliding scale is applied, it's going to make the decision much harder to defend.
Right. So is there anything else employers should keep in mind?
I would say the most important thing to not forget is insurance coverage. A lot of plans have fiduciary insurance policies. Those fiduciary policies are different than the fidelity bond that ERISA requires. They're different than the D&O policies that employers carry. And they're not mandatory, but they're a good idea to have and they're a good idea to use. Why? Because in addition to being there to cover the personal liability that fiduciaries can be faced with under ERISA Section 409 for breach of fiduciary claims, those policies will actually typically cover the cost of defending these denial of benefits claims. They almost without fail will not cover the cost of the benefit. So if a retiree is ultimately awarded several $100,000 more than the plan decided, those policies won't pay for that, but they will pay for the defense costs, which as in all litigation can be pretty high. Oftentimes they can be higher than the benefit itself, but the plan, as it should, as any employer would wants to defend something when they feel like they're right. And so I think these are good policies. I've handled claims, a number of claims under these policies through the carriers that insure these plans. And again, it's up to each plan to decide on a case-by-case basis. There's costs and benefits to weigh. But by and large, these policies are very favorable, especially because they can often cover the damages that are awarded on top of the benefit. So while they won't cover the benefit itself, they might cover attorney's fees if the plan loses. They might cover the interest that is awarded. And those can oftentimes be very significant. So I found in my practice that plans are very glad to have these policies when these denial claims go the distance.
Okay, well, that'll wrap up our discussion. Thank you, Zan, so much for joining us on the Benefits Companion.
Absolutely. Thanks for having me.
If listeners have any questions or suggestions for future episodes, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.